Okay. Good morning, everyone. I see there's 15 of you. It's about half the class. Oh, here come a few more. Okay. Can everybody hear me? Just like wave or something if you can hear. You can hear? Okay, very good. So today what we're going to do is finish up the lecture on the criminal trial. And today you are going to take your first online quiz. So I sent an email to everybody about downloading Respondus Lockdown Browser. Please let me know if you did not get that email or if you are having trouble downloading that software. Is anybody having trouble with that? We all good? We understand what this is? Okay. So I have personally never used it, but I've been told, what? Okay. I have been told that all you do is open it up and then you can log into CitLearn through this lockdown browser. And then it would be just like you're on CitLearn. It just locks that so that you're only on CitLearn. I believe it opens up the quiz in a separate window. And then that's the only thing you can see. You can't like check emails or open up other browsers or anything like that. So I've given you 30 minutes to take your quiz. The quiz becomes available at 8:50, which would be the end of the class. And it will be online for 12 hours. So you have until 8:50 tonight to take your quiz. Please do not try to take your quiz starting at like 8:49 p.m. because if you do that, then you'll only have 1 minute to take your quiz. So if you want to take it this evening, please make sure that you give yourself enough time because the quiz is only available online from 8:50 a.m. until 8:50 p.m. Once you start taking your quiz, you have to finish it. If you cancel out of it, whatever answers you've given will be the answers that I see. So you can't start the quiz, pause it, and then start trying to take it again later. Do you have any questions about that?
Yeah, I never got the email.
Who's saying that?
Adam.
Adam, you did not get the email. Okay, no. I'm going to make a note. Did anybody else not get the email? Okay, I'm going to send it to you. What it is, let me write this down. Check your spam folder, but I'll send it to you anyways. What it is a link to download the lockdown browser, and there's also a link for a tutorial. So they definitely recommend that you watch the tutorial to help you out just in case you have, trouble doing this. So I believe the tutorial is not very long. If you just quickly watch the video, it should walk you through exactly how you do it. If I'm not the only professor that is having you use the lockdown browser and you've already downloaded it, then you don't need to download it again. Did anybody, besides Adam, did anybody else not get that email with the link?
Wait, no, I found the email. I got it.
All right, you see it?
Yeah, we're good.
You see the 2 links?
Yes.
Okay, let me cross through that on my to-do list. Okay, so we're all good with that?
I have is it only a 5-point quiz, like 5 question?
It's exactly, yes, it's exactly like our normal quizzes. It's just virtual.
True. Yeah,
because of
that
the
makes sense.
pandemic.
Okay.
Yeah, and unfortunately I have to cancel Jeopardy.
Ah,
I don't know how we would do this.
in the running.
I know, I'm very sorry. I'm gonna try to brainstorm this weekend and think of something that we can do. But I just don't know how we can do this. If anybody has any ideas about Jeopardy, please let me know. I just don't know how we could. I just don't know how we could do it virtually. Okay. Any questions before we start going over the lecture?
Wait, how do we access the test? Do we have to like go into the lockdown and you have like a link, or is it through SitLearn?
So make sure you watch that tutorial. But what I have been told is that Tyler that's asking me that?
Yes, ma'am.
Okay. So what I've been told is you open up the lockdown browser and then you can go through to open up SitLearn. Douglas Pratt, you did not get the email. Is that what I'm seeing? Okay, let me write that down. So you open up the lockdown browser and then you can open up SitLearn and log in. And then, you know, on the left side on our class, like it's got some tabs like the course library.
Mm-hmm.
You're going to click on quizzes and then you click on quiz 7 and then you can start the quiz.
Okay, thank you.
Okay, if you're having problems with that, please shoot me an email and let me know. I will be sitting in front of my computer like all fucking day. I have meetings with students all day. If you just shoot me an email if you're having some trouble with that and we'll figure something out.
It's easy to work. Right when you turn it on, it sends you to SitLearn. You don't have like any other way to go. So it's pretty foolproof.
So let's see, is that Rivers that's talking?
Yes, ma'am.
So you're saying that when you open up the lockdown browser, it takes you straight to SitLearn?
Yes, ma'am. Like right when you turn it on, the only thing you have to do is log on to SitLearn. So it's not hard.
All right, very good. I'm glad to hear that. Thank you for that. Okay, any other questions? All right, well, we will try this experiment of SitLearn quizzes in the lockdown browser, and please let me know how it goes. Okay, so let's start the lecture. Okay, so let's see, we left off right here, I believe. This is the last slide we went over. Is this correct? Do we remember this? I'm pretty sure this is correct.
Probably, yeah, that one. Or
That was
like
the last
start
one?
on the judge.
Right. Okay. So we're starting with the judge. Okay. So let's go through this. So the judge has the primary duty of ensuring justice in the courtroom. So in the courtroom, the judge holds the ultimate authority, ruling on matters of law, weighing objections from both sides, deciding the admissibility of evidence, as well as disciplining anyone who challenges the order of the court. This is also known as holding someone in contempt of court. So this is just a charge against any violator of the judge's courtroom rules. And this authorizes the judge to, this authorizes the judge to impose a fine, or they can actually put you in jail if you piss off a judge that much. So any violation of the judge's courtroom rules, the judge can hold you in contempt of court. So it's completely up to their discretion. Usually they will warn you before they hold you in contempt of court. What's interesting about contempt of court, you may not find it interesting, but I do, is that it's not a crime. So appealing this process is pretty much non-existent. So if the judge is threatening to hold you in contempt of court, it's in your best interest to stop whatever behavior is upsetting the judge. So anybody in the courtroom can be accused of contempt of court if they're making enough ruckus for the judge to want them to be removed. And contempt of court is a pretty serious matter. They can hold you in jail for up to 2 years. It's rare. Usually it's just going to be a fine or maybe overnight in jail. But if you upset a judge that much, you cause that much of a ruckus, it's possible that you can be held in contempt of court for up to 2 years.
You know, do you remember the father of the gymnast that charged the guy, Larry Nassar or whatever, the doctor that was like molesting little girls?
Yeah.
Did he get in so he doesn't have a crime for charging the guy and trying to beat him up?
I think the judge just had him removed.
Is it just
but
it's
if
a
he
passion?
wanted to, he could either hold him in contempt of court, or they could press charges and then, for like attempted assault or something.
Oh, okay.
Something like
The
that.
contempt of court itself just isn't a crime?
It's not. It just means that you are violating one of the judge's rules.
All right.
Yeah. So if you've ever heard a judge say, like for instance, like if a defendant keeps like standing up and screaming, the judge might tell them, sit down or I'm going to hold you in contempt of court. Or if one of the attorneys has been told they cannot use a specific line of questioning and they keep starting down that road and the other side is objecting, the judge can say to that attorney, stop trying to ask these types of questions. I've already told you you cannot do this. If you keep doing that, I will hold you in contempt of court. And they can hold attorneys in contempt of court. Sometimes it's also used against people that are refusing to testify. So if a good example of this is used against organized crime members a lot. So if you grant one of them immunity for testifying against another organized crime member, when you grant them immunity, there's the condition of that immunity is that they are supposed to tell them everything and they're not supposed to be able to invoke their Fifth Amendment right of self-incrimination because they're immune to the charges. So if you then get them up there and they refuse to testify, they can be held in contempt of court, which could put them in a jail cell with the people that they were supposed to testify against. So anybody that is sitting in the courtroom can be accused of contempt of court and be held in contempt of court. So somebody that violates a judge's gag order can also be found in contempt of court. So a gag order is a judge's order that participants and as well as observers in a trial cannot publish, broadcast, or discuss publicly anything that happens in that courtroom. So there's a couple of reasons why a judge might want to have a gag order, but a common one is if the jury is sequestered. So we have the jury in like a separate motel off the interstate because the judge has held in chambers that the jury is only supposed to hear certain parts of information. If they are not sequestered and the news starts broadcasting all this extra information that they're not supposed to have, that's an example of why a judge would want a gag order. So to keep people from talking about what happens in the courtroom outside of the courtroom. So if the judge orders a gag order so that they don't taint the jury, and then somebody starts talking about it on the news or talking to that jury member, they could be held in contempt of court for violating that gag order. So again, the definition of a gag order is that the participants and observers at a trial cannot disclose the evidence or proceedings of that court. It can't be published, broadcasted, or discussed publicly. All right, questions about that?
This is kind of like not on topic, but like, is it like the movies and documentaries where like you truly can't watch like the news and stuff when you're on a jury, like especially like the long ones?
So if you're not sequestered, you should, the judge will tell you what you're supposed to be doing. But if so, you don't have to be sequestered if you're a jury or you're on the jury. That's only very specific trials. But they may tell you not to be watching the news, or what they may just do is have a gag order. So the news can't be broadcasting anything that happens in the courtroom. So you can watch the news without being tainted. But if they're really concerned about it, like if it's a very high profile trial, like maybe the O.J. Simpson trial or the Casey Anderson trial, they may sequester the jury for that reason. But the judge may tell them, I don't want you watching the news, but it would just be safer to have a gag order.
Yeah, I think I was watching a documentary on like the OJ trial and how that took on for months, and kind of how like the jury was kind of going insane because they.
Yeah. Sometimes it might be interesting to be on a high profile trial, but then again, these trials do take months and you may be sequestered and placed away from your family. So it's not always an amazing experience to be on a jury.
Pretty great.
Other questions about this? Okay, let's talk about the right to an attorney. So remember on Monday, I was saying the Sixth Amendment has a lot of stuff in it. This is another one right here, the right to an attorney. So the Sixth Amendment to the Constitution guarantees criminal defendants the effective assistance of counsel in trial. And a series of Supreme Court decisions has established that defendants who are unable to pay for a private defense attorney will receive adequate representation at all stages of criminal justice proceedings. So once the Supreme Court established the right to an attorney, all federal, state, and local governments all face the same problem of how, in particular, they were going to secure these rights for all the people that were facing trial in their jurisdiction. So when this came around, some local governments, by the authority of state statutes or state constitutions, had already established public defenders' offices, but that wasn't nationwide. It wasn't until the Supreme Court said, you have to provide an attorney to an indigent defendant, which is somebody that cannot pay for their own attorney. So the states that did not have these statutory or constitutional mandates were required to comply with the federal requirements articulated in the Supreme Court rulings. So these states had to figure out a lot of things, and they had to figure them out very quickly. So first they have to figure out who is eligible for an attorney that is paid for by the state or the federal government, but also how legal representation was going to be provided and how they were going to pay for it. So an indigent defendant, like I said, is anybody that cannot afford their own attorney, and it is determined by how much money you make, and there's slight differences state to state about who is completely eligible to receive an attorney that the state would pay for. So let's talk about the ways. There are three main ways that the states will provide, or the federal government will provide, an attorney for an indigent defendant. So the public defender's office is by far the most common. This is what most states, jurisdictions, and the federal governments do. But there are two other ways that states can do it. And we'll start with assigned counsel. So this is a court-appointed defense attorney that is drawn from a roster of all all practicing criminal attorneys within the jurisdiction of that trial court. So basically, they have a list of all the defense attorneys in that area, and they start at the top and just work their way down. So if you are a practicing criminal attorney in that area that does not have a public defender's office, and uses assigned counsel, you may be tapped to be an attorney for an indigent defendant. So their fees are paid at a rate that is set by the state or the local government, and they're not really negotiable. And they are also, the fees are fairly low in comparison to what this criminal defense attorney would normally charge a client. Sometimes they're about 10 to 20 times lower than what they would normally charge a client. And some people argue that this directly reflects the amount of effort that they're going to put into a case.
Do areas that use assigned counsel tend to have like less lawyers practicing in those areas? Like, do they avoid areas that use that system?
Not necessarily. This is not very common. What's more common with assigned counsel is they will have a public defender's office, and if there's overflow, like too many clients for that, then they'll switch over to assigned counsel for that overflow. But it's not that people that pass the bar look to specifically avoid an area that has assigned counsel. Does that answer your question?
Yeah.
Yeah, it's fairly uncommon. What is much more common is a public defender's office. Usually you'll see assigned counsel as the overflow. Massachusetts is an example of a state that does this. Most jurisdictions have a public defender's office, and then they will use assigned counsel when there are too many clients. Okay, so public defender's office. Oops. Okay, so this is the most common one. This is a state-employed lawyer that is defending indigent defendants. A public defender's office has a full-time salaried staff, including defense attorneys, defense investigators, and office personnel. So just like you would have, so in our state, the prosecutors are solicitor generals, and they have like a whole office. The public defender's office is the same thing, just on the other side. So when I was in Florida, we call them state attorneys, not solicitor generals. And we had the state attorneys on the 3rd floor of the courthouse and the public defender's office on the 2nd floor of the courthouse. So a lot of times they will be in the same building. It's literally just a full-time salaried office. We have with the public defender side, and then the state attorneys, district attorneys, solicitor generals on the other. So this is the most common way that a state will provide attorneys for indigent defendants. So there are 2 Bureau of Justice Statistics studies that show that the public defender system is the primary method used to provide counsel for indigent defendants in the U.S. So critics do say that the public defenders actually work for the state. And I have actually seen in person, sometimes clients are reluctant to work with a public defender because they are paid by the state. They feel like they don't really have their back. So when I was working at Florida State, one of my jobs was the intern director, and I sent a lot of interns to the public defender's office, and my interns were the ones that met with the clients for the first time and were supposed to get the story of what happened the day the crime was committed. And they often had a lot of resistance from these people to tell them the truth because they felt like these people didn't have their back because they worked for the state, they paid for the state, they were paid by the state, they were working in the same building as the state attorneys. So I can understand why somebody would have that concern. So a huge caseload is very common for public defenders, and it creates sort of a pressure towards excessive plea bargaining. But oftentimes, if there are just too many clients for a public defender's office, they will switch over to assigned counsel and start giving the overflow clients to these attorneys that are on this roster. Questions about public defenders? Okay, let's talk about contractual arrangement. So this is also not very common. So what happens here is that county and state officials arrange with local criminal defense attorneys to provide for indigent defendants on a contractual basis. So if you're a private criminal defense attorney in an area that doesn't have a public defender's office, you might get a representative from the county or the state come to your office and say, hey, will you take 20% of our indigent defendants, and then you can kind of negotiate a fee. So they will tap individual attorneys. They'll look at the list of attorneys on the Bar Association, multi-partner firms, and they basically just tap as many people as they need, and they will sign a contract at the beginning of the year to say, we'll take this percentage of your clients or this many clients for this fee. So it's similar to assigned counsel in that you basically will be called at any time to do this, but with assigned counsel, you don't really know when they're going to call you. Contractual arrangement, you know at the beginning of the year you're going to get roughly this many clients and this is how much money you're going to get for it. So small law firms might actually really enjoy this to be able to have consistent clients coming from the state. Questions about this one? Okay. All right, let's talk about a jury of one's peers. So, Article 3 of the U.S. Constitution requires that the trial of all crimes shall be by jury. So jurors are citizens selected for jury duty in a court of law. And states have the authority to determine the number of jurors in the criminal trials. So most states will use 12 jurors, but some states allow for as low as 6. So it's just completely up to the state to decide how many people they want to sit on a jury. So jury duty is considered a responsibility of citizenship. And if you are called for jury duty, then you have to serve or you face fines or jail time. So they will send a notice to your house and expect you to show up. And your options are either to show up on that day or before that date, you have to contact them and give them a legitimate reason why you can't show up. So some of you may have received a jury summons while you were at the Citadel. This happened to me when I was at USC. I was living in Columbia, but I grew up in Virginia and I received a summons to sit on a jury in Virginia. And my mom just called for me and said, you know, she's living in South Carolina. She's in college right now. And I think she had to produce evidence of tuition or enrollment or something like that. And that was all they needed. But had she not responded, I could have faced fines or jail time because it's considered a responsibility of citizenship. So there are some people that are excused from jury duty. If you're a police officer or an attorney, you're excused from jury duty because they consider you to be biased. Physicians are also excused from jury duty because of public safety. The reason that this is a public safety concern is because a physician, oftentimes they're on call, and you cannot just have someone sitting on a jury, get called for an emergency, stand up and walk out. So because of that, it's considered public safety. So when I was growing up, my father was a surgeon, and he had a beeper, which he still uses because he's old and old people are stubborn. And his beeper would go off all the time. It also would always go off right before my mom would drag us to church. I'm pretty sure he did that on purpose. This man would show up the last 4 to 5 minutes of church every single Sunday. He always had some sort of emergency to attend to then. But I could completely understand why he could not serve on a jury because, I mean, he would have to rush off to the hospital all the time. So if you are a police officer, if you're a lawyer, or if you're a physician, you are excused from jury duty. And should you be called for jury duty, you just have to provide proof of that. So the last person that we often do not allow on a jury, and this is actually being contested, is a convicted felon. So the reason that this is a concern is and there's more than 2 reasons, but I'm just going to go over 2 reasons. The first one is that if you are facing criminal charges, it's not really a jury of your peers if everybody sitting on the jury doesn't have any criminal convictions. So that's the first argument, is that it's not really a jury of your peers if we're excluding people that are a convicted felon. The other concern, and we go over this in my corrections class, is that if you have served a term of incarceration and you are coming back into society, it doesn't make sense to do things that make you feel less like a member of society. So being able to come out of prison and we're expecting you to pick up the pieces of your life in a crime-free manner, it makes it easier for you to legitimize a life of crime if you don't feel like a part of the society that you're going back to. So by making you not eligible to serve on a jury, that just sort of makes you feel like you're not a part of society. So we have police, lawyers, physicians, convicted felons. Those are the most common types of people that are excused from jury duty. Also, if you've served on a jury in the last year, you can't serve on a jury again if by some fluke they call you again.
What if you just didn't know? Like you got the letter, but what if you just moved houses and you just and they arrested you?
Then you would have to explain exactly what happened. And hopefully, I mean, if you're moving, most people have their mail forwarded. So don't be dumb enough to not do that. But yeah, you would just have to explain yourself and hope they buy it. All right, so each jurisdiction determines the rules for excusing people from jury duty, but they cannot be overtly racist or sexist when they do it. So the first case that we're going to talk about is Taylor versus Louisiana. So this was in—
I had a question.
Oh, yep.
If you ignored jury duty and like 3 or 4 years later you haven't heard anything, do you think you'd be in the clear?
Probably not. There's probably an arrest warrant out there for you. Don't do that. Just don't ignore jury duty. Why did you do that? Maybe. Clark, is there an arrest warrant out there for you?
Hope not.
Wait, hold on. We need to discuss this. Why are you asking this question? Like, what has happened that makes you think you have ignored jury duty?
Well, I moved states like 3 or 4 years ago.
Uh-huh.
And then I got from the old state, I got one. But like they sent me a thing and then they never like followed up on it. But I wasn't a citizen of my old state anymore. So
Were you 18 at the time?
yeah, and I joined the military, so I was like on training too, so I didn't know about it for like 6 months after it happened.
Okay. You might want to look into that. Hopefully they had somebody that was able to sort of figure out why you never responded. But yeah, you might want to make sure that you don't have an arrest warrant for you in that state. So good luck with that, bud. Yeah. Okay, so let's all keep our fingers crossed that Clark doesn't have an arrest warrant. And we will talk about Taylor versus Louisiana. So this was 1975, and the Supreme Court ruled in this case that the exclusion of women from a jury created an imbalance of the jury pool. So shocking, Louisiana passed a state law, they were like coming up with their people that were excluded from jury duty, as each state is allowed to do, and they said no women. This went all the way up to the Supreme Court, and they said you can't be sexist or racist and say when you're excluding people from the jury pool.
Jury duty.
What?
I thought people hated jury duty.
Some people do. Some people like it. It really just depends. One of my cousins who lives in Asheville was called for jury duty for like a really high profile murder case in Asheville. Like the guy like chopped up his wife and like hit her all around different parts of Asheville. And he got to sit on that jury, and it was like, I think 3 or 4 weeks. And they didn't sequester him, but there was a gag order. And he was like texting me, and he was like, I can't wait until the end of the trial because like he wanted to talk to me about it because I'm a criminologist, and he had like some questions. But he absolutely enjoyed being on that jury trial. But if you get called for like a stupid civil matter and they pay you to be on jury duty, I think it's just minimum wage. They give you a lunch every day. But it can be quite cumbersome. Okay, so the list that they get for jury duty, they used to just pull voter registration, but in an effort to be more representative, they will pull driver's license lists as well as tax registries to try to get more people, because people were arguing that the type of person that registers to vote is very different from the type of person that does not register to vote, and it wasn't inclusive enough. So just quickly before we talk about the next Supreme Court case, I want to explain that selecting a jury is like a twofold process. So first, what they do is send out a summons for more jurors than they need. So I'm just going to give you an abstract example. So say our state allows 12 people on a jury. They might send out 20 to 24 summons, and then say 3 of those people say, you know, I can't because I'm an attorney, or I'm a physician, or I'm a student in another state. So they'll send out more than they need. And then the people that show up, then there's a process called voir dire, where the attorneys from both sides can ask questions to each juror, and they have a number of vetoes. It differs by state. But they can strike jurors that they think are going to be biased, or they think aren't mentally stable, or just people that they do not want on their jury. So during that voir dire process, they will get rid of some jurors as well until they can narrow it down to a list of 12. So the cases that we're talking about, Taylor versus Louisiana and Thiel versus Southern Pacific, that is the process that cannot be biased. When they initially send out those summons, you can't, like Louisiana was only sending out jury summons to males. And in Thiel versus Southern Pacific, we'll talk about that in a minute. During the voir dire process, you're also not supposed to be overtly racist or sexist either. So if you want to strike a jury member or somebody that's on the jury, you have to have a reason besides they're Black, or they're white, or they're Hispanic, or they're Muslim, or something like that. That's not going to go over very well. That's not to say that attorneys don't do that. They just have to be able to point to a different reason. So let's talk about Thiel versus Southern Pacific Company. So it's this case that the Supreme Court clarified specifically what the Constitution meant when they said a jury of one's peers. So what they're saying is that it's not necessary for every jury to contain a perfect representation of every conceivable racial, ethnic, religious, gender, economic group in the community. They just can't be systematically excluding one type of person. So when they send out that initial jury summons, it doesn't have to be a perfect rainbow in representation of that society in which they're a member of, but they just can't systematically say, we're not sending any to Muslims, we're not sending any to women, or we're not sending any to Christians, or whatever. Like, so when you're looking at that list of people, it doesn't have to be a perfect rainbow. They just can't systematically not send a jury summons to one specific type of person. Does that make sense? We got that? Okay. So the last thing we'll talk about, the minimum requirements for serving on a jury. You have to be able to speak the language. So if you don't speak English, you can be excused from jury duty. You have to be an adult. So if you're under the age of 18, you can't serve on a jury. You have to possess ordinary intelligence, and every state's a little bit different about what that IQ level is. And you are supposed to possess your natural faculties, meaning you should be able to hear, speak, see, move, so on and so forth. That's not to say that they can't systematically exclude people with disabilities. They're supposed to be able to make some concessions for those types of people as well. But if it's like completely impossible for you to serve on a jury because of that, you might be able to be excused from that. Questions? All right, so we're all going to download Respondus Lockdown Browser, right? And we're going to take our quiz. So Once your quizzes have been taken, I'm going to grade them, and you will be able to see them on SitLearn just like your normal quizzes. The way I have it set up is that you won't be able to see your grade until I'm done grading everybody's quiz. So I'm probably going to do that. Let's see, what am I doing tomorrow? Worst case scenario, it'll be this weekend. That's probably when I'm going to do it, is this weekend, because my schedule for this week is a little crazy. So sometime this weekend, your grade should be posted. Actually, I have 1 or 2 quizzes from before spring break that I got to get through first. I was just not really wanting to touch them because I was worried there might be some coronavirus on it. So it should be dead now. So I'm going to get through those, and then I'll grade the quizzes that you guys do today. Just make sure you take it. You're done with your quiz before 8:50 p.m. We got it?
Yes, sir.
What?
Oh, I didn't know my mic was still on.
What?
Yes.
No.
Okay.
Yes.
Okay, very good. All right, so as long as anybody doesn't have any other questions, I will see you on Friday morning, and we're going to start talking about sentencing. Shoot me an email if you are having problems.
Dr. Hill,
Yes.
Joseph is having issues because he's been connecting this entire class. I was told to tell you. He's a little special.
That's not very nice. What do you mean he's having issues? Joseph?
If you look at his character, it said, like, it's been saying he's been connecting to the call like his entire class. He can't hear you. He was texting me.
For Christ's sake. Okay, I could send him the recording. I do recall, so wait, I don't see him on here. There, it says he's right here. You can't see what I can see. Tell him to email me. So he's just sitting here like watching my mouth move, like he can't hear me.
I think so. Yeah, he texted me saying he can't hear anything.
Okay. I don't know what to tell him about that. Tell him to email me and I'll send him a recording.
I told you he's special.
Tell him to email me and I'll send him a recording. Did he have trouble on Monday?
I don't think so.
Okay. All right. Do we know? I also heard from Kevin Williams, who claims he couldn't figure out how to do this. Taylor, he said he was texting you. I don't see him in here. What's going on with him?
Yeah, or he said that Monday. He hasn't said anything today.
Yeah, I don't see him on here. I told him to contact support and maybe don't try to get into the class like 45 minutes into the class.
Yeah, that's what I told him too.
Yeah, he claims he couldn't do it at all. Nobody else seems to be having these problems with the exception of Joseph. So, all right, yeah. Joseph, contact me. Maybe I'll just shoot him an email.
You have to do it in sign language so he can understand you.
Okay, first of all, I don't speak sign language, and I know he doesn't understand. Just tell him to contact me.
Well, no one speaks sign language. It's more
I mean, people speak sign language, just none of us do, okay? Any other questions?
I feel like you understand sign language. You don't speak it.
Okay,
Exactly.
fair point. Tell him to email me, and I'll send him a recording, and he gets to hear this whole conversation at the end, by the way. This is all being recorded.
Yes.
So there's that. Any other questions?
No.
Okay, see you guys on Friday. Please let me know how the quiz goes. Good luck.
Bye.
Bye.
Bye.